morning.
Good morning.
All right, ladies and gentlemen, I have about 9 o'clock. I'm going to go ahead and call the dockets. Ask for announcements from the attorneys. Anyone who's present who doesn't have an attorney, make sure I know that you're here, or if your attorney is not present. Otherwise, please keep your electronic devices on mute. Atascosa County, ex parte Ethan Daughtry.
Judge, we didn't send out notices on those. They had requested a date from the coordinator's office, but they never went through with the rest of what they needed to do for us to complete that.
Okay, you set on request.
May I be excused, Judge? I think that's all for Atascosa.
Yes, ma'am.
Thank you, Judge.
All right, Frio County, 1810-384, in the interest of JJR Jr., a child.
Good morning, Your Honor. Sylvia Rodriguez on behalf of the mother. We're set for final hearing on this. I know that the Attorney General, Ms. Reed, is on, and they've intervened on this case. I'm looking for my client on the screen. Alejandra Reyes, are you there? If I can check on her, Judge, and also if the father, Jesse Joe Ramirez Reyes, are you on? And if not, if they could call his name outside the courtroom, Judge.
Okay, I'm going to wait until about 9:30 just because we have so many, I've had too many defaults.
Yes, sir. Yes, sir.
Because people had trouble getting on with Zoom. But,
yes.
Yeah. All right, in the matter of the marriage of Robert and Tanya Longoria.
Your Honor, I'm on that one as well. That's set for a final hearing. We have an agreed divorce that we're going to submit to Your Honor for your approval. Prove up maybe 2 minutes, Judge.
Okay,
Mr. Longoria is on there.
I'll mark you number 1.
Thank you, Judge.
In the interest of Evelyn Castillo, a minor.
I'm here, sir. I'm her mother.
Okay, and are you ready to proceed, ma'am?
Yes, sir.
Okay, I'll mark you A. All right, Karnes County, estate of Elizabeth Moss, deceased.
Your Honor, Joe Jackson on behalf of Kathleen Moss is the independent executor. I believe we were set for a hearing to come back, I guess to enter an order on one of the beneficiaries' complaint to supplemental inventory. I actually just got approval on the order I proposed, got approval on that last night. So we just have an order for the court, and we could have a hearing on our supplemental inventory that was filed last week pursuant to the court's oral ruling at the last hearing. So 2 minutes.
Okay, is Mr. Finkel here?
No, Your Honor. I don't know if he'll be here or not.
All right, I'm going to ask you just to get in touch with his office and see if we have to redo something. Wilson County, in the interest of Elena Markworth, a child.
Good morning, Your Honor. Troy Barrientos here for petitioner William Markworth.
Right. Is Felicia Markworth here?
Yes, Your Honor, I'm here.
Okay. And what do we have to hear this morning?
If we can, I have not ready. I'm actually here today covering for Chase Butler. He had a family emergency last night. So if we can, Your Honor, if we can drop today's setting and notice Miss Markworth for about maybe another 2 weeks to reset this hearing.
Okay, and whose setting is it?
It's ours, Judge.
Okay. All right. Ms. Markworth, do you understand they're asking for more time?
Yes, Your Honor, I do.
And are you objecting?
It's been getting pushed back a lot. And I really want this matter solved. But if it's only 2 weeks, I can handle that. But any more time, I really would like this matter solved as soon as possible.
All right. Well, let me ask the two of you to get with Ms. Riley from the court administrator's office and see if you can agree on dates.
Okay.
You
Thank
want to
you,
look
Judge Aaron.
on the court administrator's webpage. It will tell you what dates are available on the calendar. The matter of the marriage of Marlene and Billy Herrera.
Yes, Your Honor.
I'm here.
And are the two of you ready to proceed?
Yes.
Yes.
I'll mark you B. Cassandra Blackman versus Stephen Blackman.
That case was dropped, Judge. They have an agreed order filed.
Fred Lissy and Agnes Ramos versus George Golick et al.
Here for Agnes Ramos, Your Honor, this is a motion to compel. We've conferred, narrowed the issues. I think it's about 20 minutes.
And I'm here for the Golicks, and I agree it's about 20 minutes.
Okay, I'm going to ask the attorneys to post copies of anything that I need to look at in chat. And I'll put down 20 minutes.
Yes, Your Honor.
Matter of the marriage of Elizabeth and Remington Koenig.
Good morning, Your Honor.
Right, ma'am. Are you ready to proceed?
Yes, sir.
All right, I'll mark you C. You'll be the third self-represented case I call up.
Okay.
Olivia Pena versus Roger Hubert or Hubert.
That's been dropped, Judge. You have a Rule 11 agreement.
Matter of the marriage of Ariana and Paul Brazelton.
Good morning, Your Honor. Lee Sturmel for the respondent, Paul Brazelton. I do not see Deanna Whitley, but could you please? Oh,
Meredith Holmstrom here on behalf of petitioner, Ms. Brazelton.
could you mark as confirmed?
I will.
Thank you.
Thank you.
All right. Anyone else told to be here today, your case was not called. All right, then I am going to make Ms. Riley the host, ask her to make me the co-host so she can work on breakout rooms. And the matter of the marriage of Robert and Tanya Longoria.
Yes, Your Honor. Mr. Longoria, I know you were on here. I'm trying to find you. Can you unmute yourself? And Judge, we're ready to proceed, Judge.
Okay, he's unmuted. All right, Mr.
Okay.
Longoria, can you
Yes, sir.
move because you're silhouetted and all we can see is a silhouette. Can you move where you don't have a bright light directly behind you?
Right.
That's better. All right, would you raise your right hand?
Can you
Do
understand
you
that?
swear or affirm the testimony
Okay,
you
go
may
ahead.
give in the matter now on
We
trial
gotta
will
call
be the
them
truth,
together.
the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, go ahead, Ms. Rodriguez.
Thank you. Could you please state your full name?
Robert Longoria Jr.
And you are the petitioner in this case, is that correct?
Yes, ma'am.
And have you been a domiciliary of Texas for the preceding 6 months?
Yes.
And a resident of this county for the preceding 90 days?
Yes.
And you are currently married to Tanya Ray Pena, is that correct?
It's Renee Reyes.
Okay, and did you and Ms. Tanya get married on or about July 1st, 2017?
Yes, ma'am.
And then you ceased to live together in November, is that correct?
Yes.
Has the marriage between you and Tanya become insupportable because of discord or conflict of personalities?
Yes.
And is there any reasonable expectation of reconciliation?
No, ma'am.
Okay, now during the marriage, you and Tanya were blessed with 2 children, is that correct?
Yes, ma'am.
Is that Trey Anthony Longoria and Tiana Renee Longoria?
Yes, ma'am. It's Rayanne.
Rianne. I'm sorry, I mispronounced her name, excuse me. Now, have you and Tanya been able to reach agreements regarding conservatorship, regarding child support, regarding possession and access, and regarding health and dental insurance?
Yes, ma'am.
And is that agreement outlined in your agreed final divorce decree?
Yes, ma'am.
And my understanding is that you believe that this agreement that you and Tanya have reached is in the best interest of the children.
Yes, ma'am.
You're asking this honorable court to follow that agreement?
Yes.
Okay. And is it also correct, sir, that you and Tanya have been able to reach agreements regarding the division of your community debt and also the division of your community property?
Yes, ma'am.
Do you believe that that agreement is fair and equitable?
Yes.
And in that one, we actually are making a correction on it this morning because what you were awarded was the debt associated with the home, but we've added in that you're also awarded the home. Is that correct?
Yes, ma'am.
And that Tanya will not have any obligations in regards to that loan. Is that correct?
Yes, ma'am.
Okay. And are you asking this honorable court to allow you to be divorced today?
Yes, ma'am.
Okay. I have nothing further, Your Honor. And just for the court's information, my secretary had filed with the court an agreed final divorce decree. We did notice that there was an item that had been left out, and we hand wrote that in. We're getting that initialed by Mr. Prince, Your Honor, and that final decree will be e-filed.
Okay, all right then. I'll find I have jurisdiction to hear this matter. It's been on file for more than 60 days. The respondent has appeared by counsel and has agreed to the entry of the divorce decree, which is being signed off by her and her attorney. The petitioner had been a resident of Frio County for 90 days and of Texas for 6 months prior to the time the lawsuit was filed. The marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There were 2 children born during the marriage. Is that correct, or 3?
There were 2, Your Honor. He
Okay.
did, yes, you're correct, Judge.
Okay, all right. There were 2 children born during the marriage, and no other children were born, adopted, or expected. I find that the proposed division of the marital property of the orders concerning the children are in their best interest, and I will approve them. And also find that the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. And pronounce the divorce in open court, and I will sign it as soon as it gets to me.
Thank you, Your Honor.
Okay, all right. All right. In the interest of Evelyn Castillo, a minor.
Yes, Your Honor, I'm here.
All right, ma'am. I've had 2 computers go out on me, so that I'm down to my backup personal laptop. I'm supposed to, a new computer for my state computer has arrived, but it has not been set up by the IT folks yet. So I do not at present have access online to the Frio County District Clerk's records. So let me ask, do you have a proposed order in this?
Basically, I was petitioning in order to have my late husband added to our daughter's birth certificate. And I needed a judge's approval or signature in order to send it to the state and have it corrected since he passed away.
And was she born during the marriage?
No, sir. He was at work, and it was before we had gotten married.
And is Frio County online?
Yes, we are.
Can you post in chat a copy of whatever documents Ms. Rios has filed?
Okay, the only thing we have is the actual petition. There's nothing else.
Well, I guess there's no one to serve. All right, if you would post just that, I'd appreciate it. I'll come back and look at it.
I will do that, Judge.
Thank you.
All right, in the matter of the marriage of Herrera,
Yes, Your Honor.
Yes.
all right, has there been an attorney general case with your children for child support?
No.
Okay, I noticed that there are vast numbers of blanks in your proposed divorce decree that need to be filled out. There's nothing about child support. There's not specific orders about insurance.
We agree to that upon ourselves, Judge.
What does that mean?
With my job, I'm off half the month. I'm gonna get them on the days off. Therefore, we decided no child support was going to be asked for. As far as insurance, I agreed to send her money monthly for my children, and we didn't find the need to put it on the court order. It's something that we agreed upon civilly.
Okay, and you have on page 8, there is a box checked that there is a modified possession order attached as Exhibit A. I do not see a modified, I don't see an Exhibit A.
I must have forgot to attach that. I'm sorry about that, Judge. Is there any way I can get it to you here in a minute?
Yes. So if you want to bring that to the clerk's office.
Okay, I can go.
Now, I've got to tell you that I have a Zoom meeting I have to appear at from 11 until 1.
11 to 1.
So if it's not finalized by 4, I haven't told anyone that yet, but if it's not finalized before then, it'll be after 1 o'clock.
Okay.
So I'll wait on that. Okay, in the matter of the marriage of Koenig.
Your Honor.
All right, is Remington Koenig here? Ma'am?
He should be. I think he's on here somewhere.
Okay, here's a Remington, asking him to unmute.
Yes, sir.
All right, Mr. Koenig, you are barely understandable.
Yeah, I'm on a frac right now, so my service is not the best.
Okay, are you ready to proceed?
Yes, sir.
Okay. And does someone have the proposed divorce decree?
Judge, the proposed divorce decree is in e-file. We have not forwarded it over to you yet.
Okay, if you could just put it in chat.
In chat, okay. It'll take me just a couple of minutes.
Meanwhile, let me ask both parties, do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
All right. All right. Ms. Koenig, prior to the time you filed this lawsuit, had you been a resident of Wilson County for 90 days and Texas for 6 months?
Yes, sir.
And you're married to Remington Koenig?
Yes, sir.
And has the marriage between the two of you become undermined due to a discord or a conflict of personalities?
Yes, conflict of personality.
Okay. Is there any likelihood the two of you are going to reconcile and live together as husband and wife again?
Likely no, sir.
Okay. When did the two of you marry?
October 24th, 2020.
Okay. And have there been any children born to you since that date?
No, sir.
Are you expecting a child?
No, sir.
Excuse me. All right. Now, I need to tell both of you, you have not been married for very long, but the law presumes that at the moment you get married, that every single thing you own is community property. It's not a matter of whose name is on the property. It's not a matter of whether the two of you are fighting over it. The law presumes it's community property. If the divorce decree does not divide up your property, does not either say something is community property and who it gets it, or say that it's not being divided up because it's not community property, then the law presumes that you still own it together, even though you're divorced. In decades from now, the ex-spouse or the ex-spouse's creditors can come back and claim that they're entitled to get a portion of it. So it's very important that your divorce decree spell out for anything that either of you own that's valuable enough there might ever be a lawsuit over it, who gets it. So let me ask, is there anything that was not described in the divorce decree that should have been, that you want to go back and add into your divorce decree as far as property is concerned?
No, sir. We don't have any assets, property or anything like that. The only thing that we have between us is his everyday driver. It's a 2012 truck. And that's outlined as I'm relinquishing that to him.
Okay. All right. So let me look at your proposed divorce decree. Well, and that vehicle was purchased during the marriage?
It was not, it was purchased before, but our names are both on there.
Oh, well, okay, then that's fine. Okay, and you're asking to have your previous name of Hernandez restored?
Yes, sir.
And do you think that just dividing this property up so that he gets the truck and apart from that, you each keep whatever is in your own possession, is that a fair way to do it?
Yes, sir.
All right, Mr. Koenig, do you have any questions for your wife on this matter?
No, sir.
Did you hear what she testified to?
Yes, sir.
Is what she said true and correct?
Yes, sir.
And do you also believe then that this is a fair way to divide up your property?
Yes, sir.
Okay. All right, I'll find I have jurisdiction to hear this matter. It's been on file for more than 60 days. There's a waiver of citation in the proper format. It's been on file more than 10 days. And the respondent has both appeared in open court and signed off on the divorce decree to indicate he agrees with it. The petitioner had been a resident of Wilson County for 90 days and Texas for 6 months before the lawsuit was filed. The marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There were no children born or adopted during the marriage, none are expected. I find that the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. I will restore the petitioner's previous name of Hernandez and pronounce the divorce in open court. Now, there is one more document that I don't know if you filed it already or not. It's called a BVS, or Bureau of Vital Statistics sheet. And that is just a fill-in-the-blank form that reports this divorce to Austin. Have you provided the district clerk's office with one of those?
I have not. I was unaware that I needed to, but I can do that today.
Okay, Ms. Kruger can get with you on that, and that's the only other thing you need to file.
Okay.
Okay. Just a moment. All right, Ms. Kruger, I've just posted that to you.
Okay, Judge, I see it.
Okay. All right, y'all are excused, except for you might get with Ms. Kruger in chat and figure out how to get a copy of that form to her. All right, let me go back and look at the Gavlik or Golick matter.
Judge, 1 second.
Yes, sir.
You mind if I go drop that paper off to your clerk's office real quick so she could scan and send it to you? Might be excused temporary.
Yes, sir, you're excused. Okay, are we ready to proceed on the Gavlik case?
Yes, Your Honor.
And do they go by Gavlik or Golick? Because it's one of those families that some people like Poppy and Pape. It just depends on which branch of the family you have.
I believe it's Golick, Your Honor.
Golick, okay.
Morning, Your Honor. This is Bill Oliver. I represent Fred Lissy and Agnes Ramos, his mother. I'm going to give a little background, and Mr. Scott's going to address the discovery issues. We represent Agnes and her son, Fred. Agnes is elderly and disabled. We also represent, and Fred lives out of state. In late 2014, Agnes hired George Golick Sr. and Jr. to care for her cattle. Senior is now deceased, but his other son, Kenneth, took his place, and George Jr. and Kenneth are the defendants. In 4 years of them taking care of her cattle, the herd did not grow, but the Golick's herd grew exponentially. They now lease multiple tracts and have been able to quit their jobs and buy their own equipment, whereas they used to use Agnes's equipment for her property, and then they used it also for their hay operation without her permission. In just over a year with a different foreman, Agnes has more calves sold or on hand than the Golick's had in 4 years. We estimate a loss of $372,000 in lost sales due to the Golick's selling Agnes's cattle and keeping proceeds, and also converting her calves to their own herd. We understand that to hide the sales of Agnes and Fred's cattle, the Golick's took mixed loads of their cattle and Agnes's and Fred's to auctions, to various different auctions. They admitted to an investigator one mixed load, but they do not admit going to more than the Karnes County auction. We need all auctions where they sold cattle so we can send out the subpoenas. Hay sales are the same. They had a separate account at Lissy and Eckel for fertilizer at one of Agnes's places that grows coastal hay, but they had no permission to bale and sell it. We have satellite photos of the hay, and they did not pay Agnes for the sales. There was also a written agreement for them to earn a right to a 67-acre tract, but it had no legal description and was not therefore enforceable. They breached it anyway, but when I told Mr. Campbell that it was breached and did not have a legal description, the Golick's forged one up that had a legal description and filed it in the deed records. The claims in the case are breach of contract, breach of fiduciary duty, declaratory judgment to declare the real estate contract void, forgery, theft liability act, trespass to real property, and trespass to personal property. They've been very uncooperative in the most basic of discovery, and Mr. Scott is going to address the specifics.
Yes, Your Honor, and if it pleases the court, Mr. Campbell and I spoke yesterday and agreed that we would just address this in subject matter categories rather than go request by request, if that's all right with the court.
Fine.
All right, first I'd like to address the discovery related to the cattle and cattle sales. That's interrogatory numbers 13 through 15, 17 through 21, 23, and request for production 16 through 19. Your Honor, these requests seek information on, for both the Ramos and Golick herds, the starting numbers of cattle, sales, purchases, and ending numbers. This is information that's necessary to help paint a picture of what might have happened with the cattle herds. To me, it's no different than looking at bank accounts in an embezzlement case. You want to find out which started with, what went out, where it went, what came in, where it came from, and which you ended up with. And these questions are all narrowly tailored to find that information. We also ask for some information about the types of bulls the Golicks had in their herd. We need that to get a baseline on what they had for DNA testing to figure out who did what on the cattle.
This sounds like an episode of The Ranch, but go ahead.
That's all I have on that subject. I don't know if you want Mr. Campbell to respond subject by subject, or if I should go through the whole thing, however the court would prefer.
Okay, what responses were made to those cattle interrogatories and requests for production?
They were largely objected to on the basis of overbreadth and relevance.
And was there any temporal restriction on the discovery?
Yes. The discovery goes from 2015 to the present. They started, I believe, in late 2014 caring for Ms. Ramos's cattle. So roughly a 5-6 year time period.
Okay. All right, Mr. Campbell.
So, Your Honor, just looking at that section, a large part of those questions, anything that related directly to the Golick's family cattle, we objected to on the fact that that's not what this case is. They didn't even ask questions that would directly lead to a conclusion that any conversion had happened. They asked for information on when the father even started raising cattle and what cattle he had when he
Let me
died.
ask you to direct me to a specific inquiry. I understand that the attorneys work with these all the time and they have all the information at their fingertips, but that's a very general statement.
Well, Your Honor, questions like number 14, questions number 24, those were directly related to Agnes's cattle. I believe those were answered without objection at all. It's just all of the questions, I think they had listed 13 to 15, 17 to 21. Any of the questions that were relating to the Gallic cattle we objected to because they're not relevant. And in regards to the fact that it goes back to 2015, if we're looking at a conversion case, which is what they're alleging, a large portion of that would be outside the statute of limitations to begin with. So again, none of that would be relevant. Going back to what cattle the Gallic family owned when George Gallic Sr. died would be completely irrelevant at this point.
Well, it's relevant to establish a baseline, Your Honor. I mean, if Ms. Ramos's herd didn't grow at all and the Gallic's herd grew at 4 or 5 times the rate you would expect it to naturally without, outside purchases that they can verify, that definitely indicates that something's going on. So I think that's all completely relevant to, or at least likely to lead to the discovery of admissible evidence as to what happened with this cattle.
And I don't believe that that would necessarily indicate that anything is going on. If you ask what the starting herd was when George Gallic Sr. died and what the herd is now, that doesn't indicate the conversion happened. It just shows that there was growth. There's a lot of different factors that can go into growth. The size of their herd is irrelevant to if there's conversion. If I have 10 Ferraris in 2010 and I have 13 now, that doesn't mean I stole your Ferrari.
Well, the standard for discovery is not 100% certainty, Your Honor. It's relevance and likelihood to lead to the discovery of admissible evidence. If he had 10 Ferraris at the beginning of the year and 13 at the end, and he can't show that he bought one and my red Ferrari is missing, that's something.
Anything else, Mr. Campbell? On that cattle issue?
I believe on the cattle issue, Your Honor, that's basically the crux of it. I would also like to point out that, like on the request for production, I raised the objections. Other than producing, essentially, if there's a document that was there, it was produced, even though I objected. And any of the interrogatories, my client is averring that his statement is correct. So on the interrogatory that was directly relating to where he sold cattle, if he said he only sold in Karnes County, the objection isn't going to change that answer. He's not hiding anything behind the objection. I'm raising the objection because the question is bad or inappropriate, but the answer that there is truthful.
There's more than one auction in Karnes County, I think.
And his statement was that all of his stuff was there. He has it directly. I don't remember what question that was specifically, but he states what auction he sold everything to and gave the name of the investigator that did the investigation at that auction. So they're fully aware of what auction that is. We raised the objection because the objection is appropriate, but my client still answered the question truthfully.
All right. What's the next category?
The next category would be the contention interrogatories and the related requests for production, Your Honor. These are very basic. They're simply asking about specific contentions that the Gallics made in their responses. For example, interrogatory number 1, explain the legal and factual basis for your contention in paragraph 3 of your answer that, quote, plaintiff's claims are barred by fraud. All these questions are like that. They cite to a specific allegation, a specific paragraph in their answer or counterclaim. These aren't controversial questions. They were all objected to on vague and ambiguous and relevance basis, and I don't think those objections are well taken. Talking to Mr. Campbell, I think I understand his position is that they're too broad because I shouldn't be asking about fraud, but I should have a separate interrogatory for each individual element of fraud, which I've never come across that before. I've never had anyone argue that I need to burn 6 interrogatories to find out someone's contentions about a fraud claim. So I just like these objections removed and the responses fully, or the discovery fully responded to. So I have notice of what the claims against my client are or their defenses.
All right, Mr. Campbell.
Your Honor, the objections that were raised there in interrogatories 1 through 7 and production requests for productions 1 through 7 are based on the fact that he gives an overall statement that is such a broad legal concept. Entire books are written on the subject, and these are interrogatories to a lay client, not to an attorney. So the client answered them the best of his ability, even with my help. But the reality is they're just too broad of statements. So the objection is correct. A lay person can't understand what you're asking. I helped him, so there is an answer there as to the best of his ability, but that it's just too big of a question. Now, the questions that weren't overly broad, because not all of them are objected, like the other side is trying to paint, like questions 3 and questions number 4, were not overly broad, and those were answered without objection, because those laid out a specific part of an element that can be answered clearly. Everything else, if you're looking at the overall claims of fraud, all the specific legal and factual basis of something, treatises are written on subjects like that. That's just way too overbroad.
Well, I'm not asking for an exegesis on, contract or fraud law. I want the specific allegations they're making. They are lay people, but I'm entitled to their answer with some help from an attorney. I don't think asking about the specific actions, sentence by sentence, paragraph by paragraph that they pled is outside, and the rules specifically authorize interrogatories of this type. So I think my client's entitled to know what the claims and defenses of the other side are.
Okay. Go ahead, Mr. Campbell.
And the questions don't even ask for just in general. They ask for the specific legal and factual basis. The problem with a question like that is ultimately when we're in trial, if they raise an objection to something I present because it wasn't provided in the interrogatories, it traps my client into something that can very easily be overconstrued based off their questions. My client did provide answers. So this idea that he doesn't, that he's entitled to something more is just wrong. My client provided the general and factual basis, which is what the rules allow. He is not required to state every specific fact and detail that could be presented at trial.
I understand that he doesn't have to, you don't have to marshal your evidence, but it looks like, but you don't think you need to give a better answer than I don't know because I don't know what that means? I mean, if that's going to be his position at trial, that's easy. But if he's going to smarten up between now and when this goes in front of a judge or jury, do the plaintiffs not have a right under the rules to understand what he's going to be contending at trial?
Your Honor, that wasn't the original. That was after we had to go back because they wanted more. But if you look at like question number 1, my client answered, plaintiff induced the defendant to enter into an agreement to purchase property in which he had no intention of complying with after many years of stringing along the defendants. Like, this is a general factual basis for their claim on why it was barred by fraud. That's a legitimate answer on the general statement.
Now, I have a copy of the first amended responses. Is there something more recent than that?
Your Honor, what I posted in the chat was the most recent response. That was separate than was attached to the motion.
All right, I have one from March the 16th.
March 16th would be the most recent one.
Okay, all right.
Your Honor, if you, the italicized was the amended answer. because they wanted something more specific. The part that is below that was the original answer, which was the general factual statement on how the claim is barred by fraud. I think the original answer is appropriate under the rules. The fact that they want something more specific, even though the question doesn't lay out anything for my client to answer. In comparison, if you look at interrogatory number 3, you can see something that is far more specific. It would be an element, and my client answered without objection.
I mean, their answers are their answers, Your Honor, but at the very least, I would like their objections to be struck so I know that the answers are complete here. And I would point out that through what I believe was a technical issue, but still under the rules, the interrogatories were filed or served on me a week after they were due pursuant to an extension. So, I mean, technically under the rules, all of the objections should be struck on that basis alone.
On that issue, Your Honor, everything was sent through the e-file. Something went wrong in the e-file system. I even provided them with the envelope number showing it was sent.
All right, and I'm not going to strike it on the technicality that the time to answer was extended, but the time to object was not, if that's what the argument is.
No, Your Honor, it was a week after the deadline to respond or object. I'm certainly not cutting it that fine.
Okay, all right. What's the next category of disagreement?
The next category would be documents related to the sale and cutting of hay. And I should have covered this with the cattle, Your Honor. It's the same arguments there. You know, when was it cut? Who cut it? Who got the money? Where was it sold? All of that to gain a picture of whether there was any potential misappropriation here. So same argument there as with the cattle.
And Mr. Campbell?
Your Honor, yeah, it's the same responses. It's anything related to Ms. Ramos's hay was responded to. Anything that directly relates to my client's hay was objected to because it's not relevant to a conversion claim. Either they can identify that hay was converted or not. Many of these were outside of the statute of limitations for conversion, and one of them was objected to. What they have listed as 25 was actually the 26th interrogatory was objected because there's just too many.
Okay, Mr. Scott?
We did go one over on the interrogatories, Your Honor, but he actually responded to that one and I didn't have an issue with it. But no, I don't have anything else to add, Your Honor. I think that's all relevant to show baselines which started. The Liability Act is a 4-year statute of limitations, as I understand it. So I think this is would all be within the statute of limitations. But in any case, the information is still relevant, even if it's outside, to develop starting points so we can look at the end point. The number of Ferraris we started with versus what we ended up with, to use Mr. Campbell's example.
Okay. All right, anything else?
Not on the hay, Your Honor. There's 2 remaining categories. One is records relating to labor performed under the contract Mr. Oliver talked about. There, the alleged contract here was the Golics would work Ms. Ramos's herd. They would get credit for that labor towards the purchase price of the land. So this is just seeking their records on the hours they worked. I also ask about their outside employment during the same time, which is relevant to determine if the hours they report are valid. I mean, if they were working, 50, 60 hours a week, a full-time job, and we're reporting 30 or 40 hours of work on Ms. Ramos's property, that also indicates there may be an issue. Mr. Campbell has produced some documents showing the hours, but there were objections to these. If he's produced everything he has, that's fine, but I just like the objections removed so I know I'm getting all the documents and nothing's hiding underneath these objections.
All right, Mr. Campbell?
I did object to the request for production, just because it asked for all documents. There's a broad category of which I could see that can go south, but I'm really not as concerned with that. All documents that we could think of and find have been produced. And the interrogatory question, I believe it's 21 or 22, depending on how you're counting it, is irrelevant. What he works outside of the working on the Agnes property is irrelevant, especially since this is a family issue. There's multiple people that could be there. I don't even think it's relevant at all in the first place. Even if he's working 50 hours at another job, that doesn't mean he can't put in more hours on her property. So unless he was working 24/7 on 2 different jobs, the possibility is always there that he can work. So it's an irrelevant question.
I mean, again, the standard for relevance isn't it must show, it's that it tends to show or might show. And as to the all documents being overbroad, I am happy to agree on the record to change anywhere that says that to documents sufficient to show. I'm not trying to trap him because he didn't look under the couch cushions for a crumbled up receipt or something like that, Your Honor. So happy to do that. The final category is information and documents related to taxes and insurance on the property they worked. As part of this contract, they were also required to pay taxes on the property they were working and insure the improvements on the property. That's completely relevant, as if they didn't do this, they were in breach of the contract they're attempting to sue on. So I just want any documents that they're going to show up with at court to claim that they complied with that. I know he's produced some documents, but again, there's objections, and I'd like those removed to know that I have everything that's going to show up at court.
All right, Mr. Campbell.
Yes, Your Honor. Everything that my client has been produced. I maintain the objections because no demand or opportunity to cure any defect in the obligations under the contract has ever been sent. So I don't believe they have a standing claim on that. So it's irrelevant legally. So that's why I maintain the objection, even though all documents that are related to the issue have been produced.
That's all I have, Your Honor.
All right, Mr. Campbell, anything else?
Nothing further, Your Honor.
Okay, I will sustain the Golick's objection to the interrogatory number 26. And with Mr. Scott's narrowing of his request for production on the labor credit hours, with that narrowing, which I'll accept, I will overrule all the rest of the Golick's objections. And Mr. Scott, are you going to reduce that to writing? Do we need an entry date?
I'll prepare an order. So I'm to understand you're overruling their objections in all those categories, the cattle, the hay,
yes,
everything as limited by my agreement to change all documents to documents sufficient to show.
Yes, and I'm sustaining number 26.
Yes. Interrogatory number 26.
All right, anything else?
Thank you, Your Honor. How should I get the order to? Just send it to the court coordinator?
Yes, I'd like to give Mr. Campbell a chance to look at it, and if you can sign off on just the form, please do so. If you cannot, please submit your own proposed order, Mr. Campbell, and I'll see which one looks better.
Yeah, sure. I'm sure we can agree. Thank you.
Thank you.
All right, good luck.
Thank you, Judge. May we be excused?
Yes. Okay. Thank you. I think it's right here. Okay. All right. And Ms. Rios,
Yes, Your Honor.
do you have your proposed order?
Not on me at the moment. I got out of town last night when the weather got bad, and I'm staying somewhere else right now. I'm sorry.
Okay. The district clerk's office there very kindly sent me all the documents. I see that your late husband, before he passed away, had signed an acknowledgement of paternity.
Yes, Your Honor.
I was very concerned about this matter because there's a way to have basically a lawsuit to determine paternity even after someone's passed away into the estates code. And I was afraid I was going to have to tell you that you need to go file one of those. But because he signed that acknowledgement of paternity, I will by all means sign your order whenever it gets to me.
Thank you, Your Honor. I greatly appreciate it. Thank you so much.
All right, Ms. Rodriguez, do we have an announcement in JJR? Did anybody ever appear?
Your Honor, my client is on here as Alejandra, and Ms. Reed with the Attorney General is likewise on here. I did need Mr. Jesse Joe Reyes' name called outside the courthouse. My understanding is he has not appeared on the screen.
That is correct. His name was called out.
Okay, and you need to have your client sworn in?
Yes, Your Honor, if that's okay with the court.
All right. And what is her last name?
Alejandra Reyes, Your Honor.
Okay. All right, Ms. Reyes, I'm going to ask you to unmute your computer.
Okay.
All right. Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Go ahead, ma'am.
Thank you, Your Honor. I just want to inform the court that this is a matter that has been pending since 2018. We came before this honorable court at that time and asked for temporary orders. We asked for a restraining order. We even asked for a writ of attachment at that time, Your Honor, because Mr. Reyes had taken possession of the young child and was refusing to give the child back to my client, Alejandra Reyes. The court was generous enough and even gave us a writ of attachment, but unfortunately, by the time that we tried to serve the same, Your Honor, Mr. Reyes had taken the child, had left the state of Texas, and Ms. Reyes did not know where the child was. She did not have contact with the child for quite a while, for months at a time, Your Honor. I think when Mr. Reyes finally contacted her, it was for a couple of minutes that she could talk with the child over the phone. But the situation got pretty bad because the little boy was under seizure medication. He had an upcoming appointment. Mr. Reyes had taken the child and had refused totally to return the child. Months later, Your Honor, Ms. Reyes had to travel to California to take possession of her child again, Judge. So I just wanted to give you a brief summary on it. I know that you're aware of it, Judge, but I just wanted a little brief summary so that you will know why we're asking for some of the things that we're asking to take place today.
And that's fine. I have some recollection of the case, but I would not have put the two together if you hadn't have reminded me. Go ahead, ma'am.
Thank you. Alejandra, could you please state your name?
Alejandra Reyes?
Okay. And Alejandra, you are the mother of Jesse Joe Reyes Jr. Is that correct?
Yes, ma'am.
Okay. And Mr. Jesse Joe Reyes is the father. Is that correct?
Yes, ma'am.
And you're asking this honorable court today in regards to conservatorship to name you as sole managing conservatorship over your son.
Yes, ma'am.
And that Mr. Reyes be given possessory conservatorship. Is that correct?
Yes.
Okay. You're asking in regards to possession and access that you want it to be supervised. Is that correct?
Yes.
And is that because Mr. Reyes has basically wrongfully taken possession of the child and refused to return the child to you?
Yes, ma'am.
Are you fearful that if he has possession of this child that he once again will do that?
Yes.
Okay. And last time he took the child, he had the child for over 3 months. Is that correct?
Yes, ma'am.
Okay. And it was a difficult time because the child did not have his seizure medication. Is that correct?
Yes, ma'am.
And is it also correct, Alejandra, that he had doctor's appointments that he missed because of Mr. Reyes's wrongful possession of the child?
Yes, ma'am.
Okay. Now, you are agreeing that he have supervised visitation at Child Safe, is that correct?
Yes.
And that be on the third Saturday of each month from 9 to 12?
Yes.
Correct? And that he be
Yes, ma'am.
responsible for the payments of those fees?
Yes.
Okay. You are asking in regards to child support that he pay the minimum of $280, is that correct?
Yes, ma'am.
Okay. My understanding is that the child is currently on Medicaid. Is that correct?
Yes.
Okay,
Yes.
so you are asking that he pay $50, which is a payback to reimburse for the Medicaid as well,
Yes.
correct? And that is included in the proposed order that we're going to submit to Your Honor today. Is that correct?
Yes, ma'am.
We are also asking for a bond as security for his visitation. Is that correct?
Yes.
Okay, and is that because you had to travel to California and try to get your son back?
Yes.
Okay, and do you believe that the request that you are going to submit to Your Honor for consideration in your final order, do you believe that all those are in the best interest of your child?
Yes, ma'am.
You're asking this honorable court to approve those requests?
Yes.
Okay. Your Honor, I'll go ahead and pass the witness for Ms. Reed.
All right, AG's office.
Ms. Reyes, to the best of your knowledge, does Mr. Reyes have any other minor children?
No, ma'am.
Okay. And to the best of your knowledge, is Mr. Reyes employed at this time?
I believe so. Yes.
Do you know if he has access to medical insurance through his employer?
No, I don't.
I have no further questions for Ms. Reyes.
All right, anything else?
No, nothing else, Your Honor. We will post the final order in suit affecting the parent-child relationship. We'll e-file it, Your Honor. We'll post it on chat, Your Honor, for your consideration.
All right, that sounds good. And has Mr. Reyes appeared in this case at all?
Yes, Your Honor. We filed an original petition back in 2018. Mr. Reyes actually on March 22nd of 2019, after the court had given us temporary orders, he filed a petition to modify the parent-child relationship. I have not heard from Mr. Reyes since that time. And my understanding is that Ms. Reed did give both Ms. Reyes and Mr. Reyes notice that we were set for today on final hearing, Your Honor.
Yes, Your Honor. Our office sent out the notice of hearing to both parties on February 11th. Since that time, Mr. Reyes has only called our office. We did freeze a bank account. He called our office and spoke with us about that, but he has not. He also requested a paternity test, which we told him he needed to talk to an attorney about. But that was the only contact that we had with him.
Okay, then we don't have to worry with the Soldiers and Sailors Civil Relief Act or whatever it's called nowadays.
That is correct, Your Honor.
All right, then I'll find I have jurisdiction to hear this matter. The case has been on file for more than 60 days. Actually, this is just a SAPSR though.
It is, Your Honor.
Yeah, okay, I still have jurisdiction to hear this matter. The respondent has been properly served and he was also appeared in court, filed a counter petition. He was notified of today's hearing. I find that he is the father of the child in question, and I'll take judicial notice of the contents of the file of the district clerk and also all of the previous testimony in this case without objection. And I'll find that he is the father of the child. I'll establish the parent-child relationship if it has not already been established between the respondent and the child. I'll find that the supposition that the respondent should have be appointed a joint managing conservator and have significant access to the child has been rebutted by clear and convincing evidence. And I will order that his periods of possession with the child be restricted as requested by the petitioner. And I will also order that child support be paid in the amount requested by the petitioner and the state. And I'll order that a bond be posted by the respondent in light of his previous actions of fleeing the state of Texas with the child and denying the child access to medical care while in his case.
Thank you, Your Honor.
All right.
We're e-filing the final order, Your Honor, and asking for your signature.
Okay, I will sign it when it comes to me.
Thank you, Your Honor. May we be excused?
Yes. Good
Okay,
luck.
and Your Honor, just one last thing. On the Longoria, it's also on chat.
Yes, I'm just looking at it right now. Thank you.
Thank you, Your Honor.
All right, Mr. Jackson, Mr. Finkel, where do we stand?
Yes, sir. Mr. Finkel's here. We do have an order on Mr. Moss's complaint to the supplemental inventory. And I guess would the court like me to submit that through chat?
Please.
Okay, I can do that. And then I guess, Judge, while we're here, we did file a second supplemental inventory adding the USAA account consistent with the court's order at the last hearing. And I don't know if we could get that approved today or not. I don't think Mr. Finkel or his client has any objection to that.
Mr. Finkel?
That's correct, Your Honor. I had signed off on the proposed order based on the court's ruling last time we had our hearing regarding our complaint. They did supplement the inventory to add that USAA account.
Okay.
And my only other issue would be if another account is discovered, obviously that be added, at a later date.
Correct, Your Honor. We have no problem with supplementing the inventory if any other state assets are located.
I had a case in Frio County where I was in high school when a lady passed away in California, and she'd been a school teacher in Cotulla in the 20s or something, and she'd bought an undivided interest in a piece of minerals out in Pearsall area. And she died in the 80s, and they finally tracked her down because they're doing so much title work, and they went back in and reopened some kind of probate proceeding, even though to supplement the inventory there in California. So that can happen 40 years afterwards. All right, then if you will post those orders to me, I'll sign them. Do we need to set anything else for hearing right now?
Well, the only other issue, Judge, is our petition to substitute the executor, and jury demand has been filed. And so we just need to get a date that the court's doing jury trials now.
Okay, you'll need to get that from Ms. Riley, the court administrator's office.
Your Honor, on the order for the complaint to supplemental inventory, I'm trying to post it in chat, but saying it's being blocked for security reasons.
Okay, are you kind of posted as a PDF?
It's a Word document.
Okay, I think it will only allow you to post PDFs.
Okay.
And you can submit it by email later if you need to.
Okay, I'll do that when I get in the office, Your Honor. I'll e-file it this morning. And the order for the second supplemental inventory has been e-filed, I believe. So we
okay, I've seen it. I'm not sure if I signed it or if I kicked it back and said, wait for hearing.
Okay.
But it will get back to me, I'm sure.
All right. Thank you, Your Honor. I'll e-file that order here momentarily. May we be excused?
Absolutely.
All right. Thank you, Your Honor.
Thank you, Your Honor.
Yes. Give me just a moment. Okay, in the matter of the marriage of Brazelton, I see the attorneys are back from their breakout room.
Yes, Your Honor. We have an agreement and are working on a short form temporary order for opposing counsel to approve and then for your signature.
Okay, excellent.
Thank you.
Thank you so much.
Judge,
Okay,
on that expunction case with Ethan Daughtry, there's a T. Morales Padilla that's online. I believe she came on
Okay.
For that case.
All right, yes,
Morning.
ma'am.
I'm here for Mr. Sharman's office.
Okay. The district clerk's office came on and announced that notices had not been sent out.
Oh, okay. You know what? Let me follow up with that because that I'm not sure. Okay. And you're talking about the notices to the agencies?
Yes, ma'am.
Okay. So then we will just reset it, I guess.
Yes, typically there'll be an order for the district judge to sign that sets it at some day that gives the clerk's office a couple of weeks to get those out. And so whatever that's 30 or 45 days plus a couple of weeks, if you just get a date from the court administrator's office and submit an order, we can get that signed.
Perfect. Thank you so much. May I be excused?
Yes, ma'am.
Thank you.
Okay. Matter of the marriage of Herrera. Oh, yes, ma'am.
I'm so sorry to interrupt. What email address do I send our order to?
Coordinator at 81-218.txcourts with an S.gov.
Thank you, Your Honor.
All right, Mr. and Ms. Herrera, let me ask you to raise your right hands. Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, sir.
Okay. All right. And you are Marlene Herrera?
Yes, sir.
All right. Ms. Herrera, before this lawsuit was filed, had you been a resident of Wilson County for 90 days and of Texas for 6 months?
Yes, sir.
And are you married to Billy Herrera?
Yes, sir.
Has the marriage between the two of you become undermined due to a discord or conflict of personalities?
Yes, sir.
Is there any likelihood that there's going to be a reconciliation where you live together again as husband and wife?
No, sir.
Okay. And when did you and Mr. Herrera marry?
November of 2016.
And since that date, how many children have been born to you?
1.
All right. And the orders that you have in your proposed divorce decree, well, actually it has, okay, was one child born prior to the marriage?
Yes.
And has there been an attorney general's case or anything else that establishes the parent-child relationship with Mr. Herrera?
No.
All right. Was he named on the birth certificate?
Yes.
Okay. All right. And are you expecting a child at this time?
No.
No. And have you adopted any children?
No.
Okay. Now I've been given a proposed divorce decree that basically says you're going to split the time with the children and you're not going to order any cash child support. Is that what it is you're wanting to do?
Correct.
Okay. I just want to make sure that both sides understand if you can do that and you can make it work out and it's fair. I mean, certainly the parents, if they're working together with the children's best interest in mind, can come up with something better than the legislature up in Austin can craft or that I can craft. You understand that the flip side of that is if it doesn't work out, you've got nothing. It's going to be a train wreck and you're going to basically have to start over from the beginning and come back to court. Do you understand?
Yes. Yes, I do.
Okay. And you think that's in the children's best interest?
Yes, sir.
Okay. Now, I also need to tell you that the law in Texas presumes that everything a married person owns is community property. So it's not a matter of whether you're having a dispute over something or whose name is on something. Anything that's valuable enough, there might be a fight over it one day, even if it's with creditors of one or the two of you, we need to know who winds up with it, whether it's community property and it's being split up, or somebody owned it, say, before the marriage and it's not being split up. Because if that doesn't happen, then the law presumes that the two of you still own that property together after you're divorced. So are there any automobiles, tractors, cows, businesses that need to be listed in the divorce decree?
We do have them, but I was under the impression that we didn't need to list them since his vehicles are in his name, mine's in my name, and neither one of us are going to go after anything.
I'm not telling you that you have to list anything.
Okay.
But it would be,
I don't.
if you try and sell the property, I mean, it just says each of you gets to keep the property in your possession. If that's going to be good enough when you go to trade a car in or something, that's fine. So do you want an opportunity to come up to the courthouse and write in what automobiles each of you are getting?
The only thing that I would like to add in there is I just recently purchased a house. And so since we are still married, he's on the deed. So.
Yeah, no, that, again, I can't be y'all's attorney, but I would, that very much, it needs to be on there.
Okay.
Okay, do you have a copy of the deed or deed of trust where you're purchasing that house?
Yes, I do.
Okay. Can you attach a copy of that to your divorce decree as an exhibit?
Yes.
Okay. Now, there's also some blanks where it says debts. There's debts to husband, debts to wife. The default in this form is that each of you will pay any debts that you've incurred in your name after the date of separation. You can actually use any date from the date of separation up to today's date. So do you think it would be good to use the date of separation?
Yes.
Okay, what date was that?
Well, technically like 2 weeks ago. So I guess the 15th.
Well, all right. And Mr. Herrera, do you agree that that's a good date to use?
Yes, sir, that's fine. She was staying here at the house until she was able to purchase her house. So that's fine with me.
All right, ma'am. And are you asking to have a previous name restored?
No.
All right, Mr. Herrera, did you hear everything that your wife testified to?
Yes, sir.
What she said, true and correct?
Yes, sir.
Do you have any questions for her at this time?
No, sir, I do not.
And do you agree that these orders are in your children's best interest?
Yes, sir.
And that is a fair way to divide your marital property and debts?
Yes, sir.
Okay. All right. I'll find I have jurisdiction to hear this matter. It's been on file for more than 60 days. The petitioner had been a resident of Texas for 6 months and of Wilson County for 90 days prior to the time the lawsuit was filed. The marriage between the parties has become insupportable due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. The respondent has appeared in open court and signed the divorce decree indicating he is agreeing to it. He's also filed a waiver of citation that's been on file for more than 10 days with the district clerk's office. I'll find that the marriage has become insupportable due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There was one child born during the marriage and no other children were born, adopted, or expected, and I find that the proposed orders concerning that child are in the child's best interest. I will approve them, and I will find that the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. And I'll pronounce the divorce in open court. All right, I am not going to sign the divorce decree at this time. I'm going to wait for one of the Herreras to come up and write in on community property that's being divided, who's getting what vehicle, and also that the community property residence is being awarded to Marlene Herrera. And there needs to be a legal description. If you just have a copy of the deed or the deed of trust and you can attach that, that's the easiest way for that to happen.
Okay.
All right, I wish all good luck, and I'll leave this here because I'm going to try to go to the house before I start the meeting I have at 11 o'clock. Let me see what else I have. All right.
Your Honor.
Yes, sir, and you're excused. And on Brazelton,
Thank you.
we're waiting on the order. Castillo, I'm waiting on the order. Reyes, I'm waiting on the order. Longoria, I have an order. All right. Give me a moment to look at that, and then I will get that to the district clerk in Frio.
Thank you. And I know on the one on Reyes, on the child,
Yeah.
that one, I think Ms. Rodriguez said that they were going to e-file that one.
Okay, yes, I think you're right.
Okay.
Okay, and in Frio County, Longoria divorce, I just posted that to the clerk's office in chat.
Thank you, Judge. May we be excused?
Absolutely.
Thank you. You have a nice one.
All right. Okay, do we want to go over the dockets?
Sure.
All right, Atascosa County. Nothing. They need to get service on that expunction.
Yes. And then in addition, there was an order signed. You didn't call that one, but we had notes that you had signed an order in the e-filing queue, I think, on
Okay.
Roberson.
That sounds familiar. Okay, and the Frio County, we're waiting on the final decree to be filed. The Reyes case, I just signed the final judgment. In the Longoria case, I'm waiting on the order adding the father to the birth certificate. In the Castillo minor case, Karnes County, there's some orders that are supposed to be submitted. I put reset on request on the Moss estate. Wilson County, Koenig, final judgment. Pena, reset on request. Brazelton, Elise Stremmel has appeared on the defense side, and they have an agreed order to be, I think, emailed. And, oh, that was page 2. Oh, wait, what happened on Markworth? Are we still?
I showed dropped. The attorney
Okay.
wasn't available, Chase Butler, for a family emergency, so it was dropped, and they're supposed to get with me to get a reset.
All right, reset on request. Herrera, final judgment to be filed, or well, yeah, final judgment to come. I need to come edit this. Blackman, reset on request.
I think there was an agreed order filed on that too, Judge.
Okay. Golick. Orders to come, reset on request. Is that everything?
I believe so, Judge.
Okay. All right. I have lots of things to work on, but I also have a pattern jury charge committee meeting from 11 till 1.
Okay.
So I'm going to go and try and work on that at the house. And I may be back up there, and then I'll just work at the house.
Judge,
Yes, ma'am.
Monday, it's in
Yeah.
person.
In person.
See you Monday.
See you then. Okay. It's been a while.
Yeah.
All right. And I got to dig out my face shield.
Uh-oh.
It'd be weird going back to regular stuff. I haven't really got to experience that so much since I was new before the COVID hit.
Right. No. Yeah.
A little bit, but not too much.
Sounds good. All right. I am going to leave the meeting. I will see y'all, some of y'all on Monday.
Thank you. Everybody have a good day.
You too.